In this lecture, we shall discuss the composition of the High Court of Ghana. The composition of the High Court of Ghana. Now, when we say the High Court of Ghana, what do we mean? Now, if you look at Article 126 of the 1992 Constitution of Ghana, the High Court of Ghana forms part of the Superior Court of Judicature. So for the Superior Court of Judicature, under Article 126, we are told that they are the Supreme Court, the Court of Appeal, the High Court, and regional tribunals. Take note of the expression, the High Court, that there's only one single High Court in Ghana. So there's only one High Court in Ghana. But if you see different High Courts, you've seen the High Court at Adenta, you've seen one at Accra, you've seen one in Tema, you've seen one in Kumasi. They are only divisions of the High Courts. They are divisions of that single High Court that is created under Article 126 of the 1992 Constitution. So the judiciary shall consist of the Superior Court of Judicature, comprising the Supreme Court, Court of Appeal, and the High Court. So there's only one High Court under the Constitution. Now, if the High Court, what is the composition of the High Court? Look at Article 139. The High Court shall consist of the Chief Justice. It means that the Chief Justice of the Republic of Ghana is a member of the High Court. So the High Court shall consist of the Chief Justice, not less than 20 justices of the High Court, and such other justices of the Superior Court of Judicature, as the Chief Justice may by writing signed by him request to sit in the High Court, sit as a High Court Justice for any period. Let me explain Article 139. First point is that the Chief Justice himself, even though he is a Justice of the Supreme Court, even though the Chief Justice is the Justice of the Supreme Court, he's also a Justice of the High Court. So he's a member of the High Court as well. So if there's a case pending before the High Court, the Chief Justice can preside over that matter. And that is on the force of Article 139, Clause 1A of the Constitution. Not only that, apart from the Chief Justice, the total number of justices we must have at the High Court at any point in time, they must be not less than 20. So at every point in time in Ghana, the composition of the High Court, it is the Chief Justice and the minimum of 20 justices of the High Courts. In other words, you must always have a minimum of 21 justices of the High Court, because the CJ is one and no less than 20 justices of the High Courts. And then apart from that, there's an interesting provision. Article 131, Clause 1C says, such other justices of the Superior Court of Judicature, as the Chief Justice, may by writing signed by him request to sit as the High Court of Justice for any specified period. What does this mean? It means that the Chief Justice can write and sign against it and request any justice of the Superior Court of Judicature to go and sit in the High Court for any period. In other words, the Chief Justice can designate any justice of the Superior Court. And remember, the Superior Court refers to the Supreme Court, Court of Appeal, High Court, and regional tribunals. What this means is that the Chief Justice can write and designate a justice of the Supreme Court to go and sit in the High Court to hear any matter. The CJ can also designate a justice of the Court of Appeal to go and sit in the High Court to hear any cause or matter. So it's very critical for you to note this. If you get to the High Court and you see a Supreme Court Justice presiding, Don't think that, hey, they have done something untoward. No, that conduct is sanctioned by Article 139, Clause 1C of the 1992 Constitution, which empowers the Chief Justice to write and sign and request a justice of the Superior Court of Judicature to go and sit in the High Court for any specified period. So that is the composition of the High Court. Now, if the High Court has to adjudicate upon a case, how many people should sit to hear that case? If the High Court should sit over a case, how many people should sit to hear that case pending before the High Court? Now, Article 139 is also very critical. Article 139 says that the High Court shall be constituted A. By a single justice of the court, or B. By a single justice of the court and jury, or C. By a single justice of the court with assessors, or D. By 3 justices of the court for the trial of the offense of high treason or treason, as required by Article 19 of the Constitution. So let me explain this. Ordinarily, if we have any matter pending before the High Court, every matter pending before the High Court, apart from offenses triable on indictment, if it's an offense triable on indictment, like murder, if you have an offense like murder before the High Court, that one, the High Court judge must sit with a jury, because the High Court judge will hear the case and then sum up the law and the facts and the evidence to the jury, and the jury will now have to go and return with their verdict. So in the trial of an offense like murder, we don't have a single justice sitting alone. The judge must sit with a jury. A jury is usually 7 ordinary lay persons appointed according to a prescribed manner laid down by the law, and there are 30. And they have to sit over there. So you see the High Court judge sitting there, and you see the 7 jurors sitting there. So the High Court shall be constituted by a single justice of the court and a jury. And I'm indicating that this is applicable in cases like trial of murder, it is tried on indictments. But if it's just an ordinary land case, an ordinary civil matter, an ordinary divorce matter, any other civil matter that you may have, criminal matter that may be tried summarily, that one, it may be determined by a single justice of the court. So that one, if you get to the High Court, you see only a single justice sitting. Only one judge will sit and hear the matter. But if it's a trial on indictment like murder, it must be a judge and then a jury. But if it's an offense like treason, that's when the law recognizes that the people that must sit to hear the matter must be 3 justices of the court. So you get to the High Court, it's treason, you see 3 High Court judges sitting there to hear the matter. And that's what you see under Article 139 plus 2D. Because of the treason, let me even mention Article 19 plus 2E of the Constitution. It says, a person charged with a criminal offense shall, in the case of an offense of high treason or treason, in the case of the offense of high treason or treason, be tried by the High Court, duly constituted by 3 justices of the court, and the decision of the justices shall be unanimous. So if you are been charged, you have been charged for the offense of treason or high treason, then when you get to the High Court, you see 3 High Court judges sitting over there, and their decision too must be unanimous. Now remember, I mentioned that under the Constitution there's only one High Court, and that's 126. There's only one High Court. So people may be wondering, if there's only one High Court, how is it that one is sitting at Adenta, another one is at Kufuridua, another one is here? The answer to that is under Article 139 clause 3, which says that the High Court, there shall be in the High Court such divisions consisting of such number of justices, respectively, as the Chief Justice may determine. So there shall be in the High Court such divisions. So all that you are seeing in Accra, in Kumasi, even in Accra, general jurisdiction, divorce and matrimonial probate, they are all divisions of the High Court. And we don't have multiple High Courts. We have only one High Court of Justice. But we have many words, divisions of the High Court. Finally, what is the qualification for appointment to the High Court? If you have to be qualified to be appointed to the High Court, the answer is under Article 139 clause 4 of the 1992 Constitution. It says, a person shall not be qualified for appointment as a justice of the High Court unless he is a person of high moral character and proven integrity and is of at least 10 years standing as a lawyer. A person shall not be qualified for appointment as a justice of the High Court unless he is a person of high moral character, proven integrity, and is of at least 10 years standing as a lawyer. This is where we shall draw the curtains on our lecture on the composition of the High Court. By way of recap, we mentioned that the High Court under Article 126 is part of the Superior Court of Judicature. We mentioned that there's only one High Court of Ghana. That even though there's only one High Court, there can be created different divisions of the High Courts. We mentioned that the composition of the High Court is that there must be the Chief Justice, not less than 20 justices of the High Court, and also the Chief Justice may, by writing signed by him, request any other justice of the Superior Court of Judicature to sit in the High Court for any specified period. And we mentioned that if you are constituting the High Court to hear any case under Article 139 clause 2, the High Court shall be constituted by a single justice of the court, a single justice of the court and jury, single justice of the court with assessors, or by 3 justices of the court for the trial of the offense of high treason or treason. And the composition of the court for treason is further reinforced by Article 19 clause 2E of the 1992 Constitution, which says that a person charged with a criminal offense in the case of the offense of high treason or treason be tried by the High Court, duly constituted by 3 justices of that court, and the decision of the justices shall be unanimous. And we finally mentioned that for a person to be qualified for appointment to the High Court, that person must be a person of high moral character, proven integrity, and not less than 10 years standing as a lawyer. This is where we shall draw the curtains on our lecture on the composition of the High Court of Ghana. Thank you.